Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal updates from 14th February to 19th February 2022. In first important news, the Supreme Court has held that a person not named in a crime as an accused has no locus to seek the quashing of proceedings. In the case of Hukum Chand Garg versus State of Uttar Pradesh, the court has held that persons who are not accused in a crime or not named in a case cannot be permitted to ask for quashing of the proceedings concerning another person. In the present case, the court held that it is not in dispute that the petitioners have not been named as accused in the said crime. If the petitioners have not been named as accused, the question of quashing of stated FIR or the case, which is now under investigation by CBI, does not arise as the petitioners will have no locus to seek such a relief. In second important news, the Supreme Court has held that superannuation of an employee does not absolve him from any misconduct committed during the discharge of his duties. In the case of United Bank of India versus Bachchan Prasad Lal, the court has held that superannuation of an employee does not absolve him from the misconduct committed in discharge of his duties. In the present case, the court said that merely because the employee stood superannuated in the meanwhile will not absolve him from the misconduct which he had committed in discharge of his duties. A bank employee always holds a position of trust where honesty and integrity are the sine qua non. In third important news, the Supreme Court has set aside the High Court order staying the Haryana law on 75% domicile reservation in private sector jobs. The Supreme Court has set aside the order of Punjab and Haryana High Court staying the Haryana State Employment of Local Candidates Act of 2020, which grants 75% reservation in private sector jobs to persons who are domiciled in Haryana. Lastly, the Supreme Court has upheld the state policy to deny bonus marks based on intelligible differentia. In the case of Satya Dev Bagor versus State of Rajasthan, the court has observed that interference in a policy decision is not required when the state is in a position to point out the intelligible differentia in application of the policy. In the present case, the court held that the state of Rajasthan has decided to restrict the benefit of bonus marks only to such employees who have worked under different organizations in the state of Rajasthan and to employees working under the NHM or NRHM schemes in the state of Rajasthan. And this cannot be said to be arbitrary as it is based on an intelligible differentia. This brings us to the end of our weekly update. If you like this video, please like and share and subscribe to our YouTube channel.